It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay. I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Listen, just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. Do you understand?
Yes.
And so go ahead.
I'm sorry, Judge.
Good morning, sir. Are you Donald Cogdill? Are you Donald Cogdill?
Yes, ma'am.
And Mr. Cogdill, can you hear me okay?
Barely.
In cause number 26 DCCR, excuse me, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true, that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Do you understand that?
The way he's talking is going to be a lot better, worse. I mean, I don't understand.
What do you not understand?
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
If I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading. So we were actually even going to come to the court with seeking your permission for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute.
Thank you.
Sure.
What about the page 4? The postal strike or that they looking screaming.
What are you going to do? Inherently to add why 15 cases, remember there's one not fixed. And they don't do those.
Brandon Benton.
Yes, ma'am.
Okay.
Put it with the.
Oh, gotcha. We are resetting Brandon Bonta.
Oh, yes, no.
Bring it back. That's going to be something.
Mr. Lewis, you have Ephraim Dinkin.
Yes, ma'am.
Morning.
No, probably be right.
Ephraim,
Good morning. Are you Ephraim Dinkin?
Yes.
And Mr. Lewis, will your client waive the formal reading of the motion?
He would.
Mr. Dinkin, and cause number 19-32080. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 12th of 2019 for aggravated assault, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation office for the months of September and October of 2023. And is that true or not true?
Yes.
True or not true? Thank you. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you tested positive for alcohol June 19th, July 12th, and August 28th of 2023. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of entering and successfully completing the anger management program as ordered. Is that true or not true? Count 4 alleges that you were behind in your court assessed fees. Is that true or not true? And then count 5 alleges that you failed to complete the drug rehabilitation orientation program, or the DROP program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Did you plead true, but did anybody force you to plead true?
Collision. The judge called it one of the worst child abuse cases in 30 years, yet chose rehabilitation over prison. In U.S. law, probation is a privilege, not a right. Would you have made the same decision? Balance scale viewers will likely be deeply divided.
Okay, do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 10 years in prison. And so as long as I give you 10 years or less, you understand that you're waiving any right to appeal, correct? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Dinkin is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing, get the probation department to do an updated report, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he'll present it to me on your behalf when we come back. All right? See you back at sentencing. You can go back with the bailiff. See, Mr. Lewis, you've got April Smith.
Yes, ma'am.
April Smith. Sending the paperwork on that.
What, I have a notation that there's new cases coming. Are those?
Have enough day.
Okay.
Yes, ma'am.
April Smith.
She's right in the CDC.
Okay, that's fine, because I think she'll probably need to get her over here first for fingerprints. Yeah. Character, Mr. Bynum.
Thought about y'all last night. Did y'all feel the boom? Never felt it.
I was thinking, I never felt it. Okay, let's see. This is.
I don't.
We've got April Smith coming. Oh, there it is. Just popped up. As soon as I said it, of course. Good morning. Are you April Smith? And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Jim.
So it's just open.
It is, Judge, and just to update the court, it's my understanding that Ms. Smith is going to plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times today to the detectives to ask them to bring those new cases. I believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just going to go open to the court on the full range of punishment with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am. Or Mr. Lewis, will she waive the formal reading of the motion?
She does, Jim.
Ms. Smith, in clause number 19-33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm going to make that change because.
The only reason I did that is because we had the agreement.
Oh,
the new
No,
cases.
it's just fine.
Okay, so there is an
Right,
agreement,
right.
actually.
There is actually.
Thank you, Mr. Lewis.
A
Mr.
high-stakes
Whitson, in clause number
legal gamble.
24,
The plea
DCCR
agreement limits prison
0198,
exposure, but
I have a
also
motion to
waives
revoke
key
your
appeal
unadjudicated
rights.
probation.
Is certainty worth
Shows that you were
giving up
placed on
future
probation
legal
July
options?
1st of
What would you
2024.
choose?
Is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them. And that's part of that plea agreement, which means no matter what I do within the range of punishment, which is up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Ms. Smith is not competent?
No.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? See you back at sentencing.
Thanks.
All right, sir. Again, you're Donald Cogdill.
Yes, ma'am.
Can you hear me okay like this?
Yes.
And will your client waive the formal reading of the indictment?
You will.
Mr. Cogdill, I have to go through that indictment again, even though I already did. In cause number 26, DCCR 0005, you are charged with the state jail felony offense of evading arrest or detention with previous convictions from June 25th of 2025. The indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. It further alleges that you were convicted of burglary of a habitation, first-degree felony, December 22nd of 1993. After that was final, you were convicted of burglary of a habitation, a first-degree felony, November 7th of 1994. That's enough for a second, if that's okay.
Yes.
Yes. How do you plead to that charge?
How you plead? Guilty?
Guilty.
And are those prior convictions true?
Yes.
Are you pleading guilty and true freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Stuff you signed, I explained to you.
Yes.
Do you understand those documents that you signed with Mr. Parker?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? So as long as, and the agreement is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And as long as I give you 8 years or less, you cannot change your mind and appeal later. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right. I have to ask everyone that. State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Cogdill is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker and he will present it to me on your behalf when we come back. All right. I'll see you back at sentencing. You can go back with the bailiff. Complete
The
the
courtroom
safety
falls
program
silent.
and the
Probation is
aftercare,
revoked,
and that you were
prison time
removed
is
from it on
imposed,
December
and
18th
the
of
consequences
2025.
become
And is that
permanent.
true or not
One
true?
hearing changed a life forever. Was this
Count
justice
2
served?
alleges that you
or
failed to
punishment
provide
too severe?
verification of performing the community service hours as required. Is that true or not true?
True.